Hi, Attorney Steve Vonder, we're back. We are talking in this video about how to dazzle your friends around the water cool, at the cocktail party, at the dinner party, with your knowledge of First Amendment free speech law. Okay, so everybody thinks they know First Amendment. Hey, we have a right to free speech. It's free speech, it's free speech. But that's what the average man is going to say. The average woman's going to say that, but not the Attorney Steve trained peeps out here. So let's, without further ado, head to the Attorney Steve litigation whiteboard. Okay, so we're going to talk just a basic overview about First Amendment law so that you know more than the average person knows. Okay, let's get down to it. First Amendment, everybody knows what that is, right? It's contained in the Bill of... Did you get it? Bill of Rights. It's in the Bill of Rights. The first 10 amendments to the Constitution of the United States. Okay? So that you have the United States Constitution, you have the First Amendment. Now I always ask, you know, everybody says, well, the founders were so brilliant. And I say, well, then why wasn't free speech in the Constitution? Why wasn't it in the Constitution? Why did it have to come later in a Bill of Rights? Just a question. Good question to ask at a cocktail party, dinner party. We're arming you with the tools, the ammunition here. Okay, so, but it's contained in the Bill of Rights. Okay, the Bill of Rights, who cares? It's in there, we got it. Okay, so you got the Bill of Rights. We're talking free speech. Now, let's talk about what the First Amendment protects. In basic, this is just a basic overview. Religious conduct, religious conversations, political conversations, symbolic expression like burning flags is protected. Yeah, so symbolic expression is protected. The right not to speak, like preventing the government from making everyone take a loyalty oath, or the Fifth Amendment right against incrimination. Okay, so you don't incriminate yourself. So we have these types of things are protected free speech. Now, even though we have that, I have written right here TPM. That stands for reasonable time, place, and manner restrictions on free speech are permitted. Reasonable time, place, and manner restrictions, permits, you know, rallies, permits, all these kinds of things. So reasonable time, place, and manner regulations are going to be upheld in most cases, okay? Now, as you might have heard some people say, freedom of speech is not absolute. And actually, real quick, before we go into it, I'm going to actually read you the First Amendment here. Okay, the Constitution actually says this. Here's the text. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press. Freedom of the press is in there. Or the right of the people to peacefully assemble. That's your getting together for your political rallies. It's known as the right of assembly. And to petition the government for redress of grievances. Okay, so I'm not exactly sure how that section plays out in real life, but it's there. Okay, so there's your First Amendment. So back to here, as you will hear people say, the smart person's going to say, the First Amendment free speech rights are not absolute. Repeat after me. First Amendment free speech rights are not absolute. Okay, so what does that mean? See, now you've just taken yourself above the average ordinary person and put yourself into the mental mode here. So you say it's not absolute. Well, what does that mean? Well, there's different classes of speech, things you can say, ways you can express yourself that actually may not be protected, may actually be regulated or governed by a statute. There may be a criminal statute that you could end up violating because you're speaking. So free speech is not always free. It's not always absolute, okay? Let's talk about some of these things. We got 1, 2, 3, 4, 5, 6, 7. We got 7, or 8. I have 8 categories here. These are things, if you can remember these, bring them up at a cocktail party and somebody says, what do you mean free speech isn't absolute? What are you talking about, Attorney Steve? Or Mr. or Mrs. You know who, and you say, well, there's some things that are protected. Let's go down them. Things that are likely to create a clear and present danger. The clear and present danger test. Now, I love this one just because it just sounds great, right? The clear and present danger test. So that's a real neat one. The common example that people will say is you can't yell fire in a crowded theater. You can't yell fire in a crowded theater. Why? It creates a panic, a riot. People get hurt all because you're exercising free speech? That's not going to go down. Okay? So your clear and present danger test. Threats. Okay, let's give an example. So if you send an email to somebody threatening to kill them, that's free speech. You're just speaking your mind, right? I'm going to kill you. But that's not protected free speech, and in fact, you could go to jail for that, okay, under some of the criminal statutes in your state, okay? Now, and we'll get to that into a second, but so threats are not always going to be protected free speech. Defamation, another big one. What's defamation? Defamation are false statements of fact about a person that injure their reputation and cause them damages. And there's two types of defamation. There's libel, which is written. Libel is written defamation, and slander is oral. So when you slander someone, you're orally defaming them. When you put something in writing and you put it in a newspaper and you broadcast it to everybody, publicate it to a third party, as they say, you're defaming them. That's libel. Libel is in writing. Okay? So I always remembered that from law school, I always remembered libel was like a label. Labels are in writing. That's how I remembered it. So defamation is not protected free speech. You can't run around and just defame people. Okay, that could wind you up in a courthouse, and you could end up paying damages to someone. Now, you have to remember when it comes to defamation, media defendants, newspapers, TVs, maybe some podcasts and things are going to get broader latitudes. Social media blogs giving their version of the news may get some more leeway under the New York Times versus Sullivan's test. If you don't know what that is, look it up. It's a topic of another video. In fact, I think I did a video on it. I just can't remember. But New York Times versus Sullivan. So there's three things that are not protected free speech, even though you would say, well, you know, why can't I do that? You can do that, but free speech is not always so free. It could actually cost you, okay? What else do we have? Not protected, not absolute. Obscenity, patently offensive, appealing to a prurient interest, as they say, in the reasonable standards of the community. As one Supreme Court justice said, what is obscenity? He said, I don't know, but I know it when I see it. I know it when I see it. So, obscenity not absolutely protected. Hate speech, hate speech that just evilly and violently goes out after other people, attacking them. Now, this is a fine line. This is a very controversial issue, but some things you may find are criminalized under hate speech statute, so you have to be aware of that, okay? Commercial speech, okay, this is very important. These things that we talked about here, the protected speech areas, religious, political, symbolic, these kinds of things, those are non-commercial. When you get to commercial speech, you're going to find that you have less protections, meaning the government can regulate more, okay? So just bear that in mind. Commercial speech, not as absolutely protected as political and religious types of speeches might be. Fighting words. Fighting words. This is an interesting one. Case on point, Chaplinsky versus New Hampshire. There was a case with I think he was a Jehovah's Witness that was calling somebody else a fascist and a fascist pig or something like that, and likely to start a fight. So he was actually criminalized under one of the New Hampshire statutes. Now, what else? Trade secrets, publishing trade secrets, breaching confidentiality agreements, breaching non-disclosure agreements. If you're under contract, okay, if you're under contract to keep something quiet, opening your mouth and expressing yourself may get you into trouble. So again, these are things to look at. So that's a basic overview of your protected speeches versus things that may be regulated, and keeping in mind your reasonable time, place, and manner statutes. So some takeaways. The First Amendment applies to the states via the 14th Amendment. Okay, if you know that, you are so far beyond everybody else. They're not even in your league. If you start talking about the First Amendment is incorporated into the 14th Amendment applicable to the states, I mean, you are killing it. You are high level, top notch, okay? So First Amendment is incorporated into the 14th Amendment, made applicable to the states. The government regulating, when the government is regulating areas of these protected free speech areas or these areas, whenever there's speech involved, you always have to look. This could be your local governments, your state governments, your federal governments passing laws that infringe on free speech rights. Bear in mind, there's different types of tests the courts may look at. The United States Supreme Court may look at different kinds of tests. But one of the tests is strict scrutiny. Strict scrutiny. Say that with me. It just feels good, doesn't it? Strict scrutiny. That means they're going to really look at this thing closely to make sure it's a narrowly tailored law, that it's essential to a significant government purpose, that it's absolutely essential that alternative channels of communication remain open. These kinds of bar exam things that we talk about, all these wonderful buzzwords to get out there in your bar exam. So, government regulation subject to strict scrutiny, compelling interest, narrowly tailored, least restrictive means, only incidental burdens on free speech. Those are the kinds of things we're looking for when we're dealing with regulating free speech, okay? Internet, be careful. Everybody's running around thinking that it's all free speech. I can say and do whatever I want. Chat boards, Facebook, anything I want. Beware. You have some of these issues, some of these areas where you may find, or your kids may end up in trouble. So you're going to want to be thinking about that, okay? Last one, and it ties in with my Facebook comments, is, some people think, well, free speech applies everywhere. It's like Facebook, they're infringing my free speech rights. You're not going to say that, because you know that Facebook is a private company owned by Zuckerberg. He's a private guy. You're not going to say that he owes you some free speech right. It applies where you have state action, okay? Where you have state action, where you have entities that are funded by the government, okay? So you need that state actor. If you have private companies, the private companies aren't so much bound by the United States Constitution as is the government, okay? So that's really important things to keep in mind here. So that's a basic overview. If you watch this through twice, 3 times, watch this video through, share it on your social media networks, you will dazzle your friends at the next party with your knowledge, your brilliance, your wisdom, your insight on the First Amendment and the freedom of speech. All right, Attorney Steve, for more information, go to my website, askattorneysteve.com. Send me your comments, emails, post here, and subscribe. I don't know if it's up here or down here. They keep moving it on me. Hit the red V, subscribe. Thank you. If you need a litigation attorney, we're here to help. Thank you very much. Have a great day.